Hello, everyone, and welcome to the live stream of the final round of the 50th Annual William B. Spong Jr. Invitational Tournament. Thank you so much for joining us this weekend virtually. I wish that you were all here in person, but we are so excited to have everyone, our final panelists and our finalists join us tonight to go through our final round. For everyone in the audience, we want to give you a brief overview of what the questions presented are for this topic and the questions that the competitors will be answering. First, where the public schoolhouse and one's home share a common space, does regulation of a student's possession of a firearm in his home violate the Second Amendment? And second, does a school's regulation of a student's off-campus interactions on social media violate the First Amendment? Our two finalists for this round are for the petitioner, Team 2135, and the respondent, Team 2140. I would like to also introduce you to our final panel of judges. Our tournament chief judge is Judge Roger L. Gregory, the chief judge of the Fourth Circuit Court of Appeals, Judge Lucy Inman with the North Carolina Court of Appeals, Justice Arthur Kelsey with the Supreme Court of Virginia, Judge Jonathan Byron with the Maryland Court of Appeals, Judge Michael Urbanski, the chief of the U.S. District Court of the Western District of Virginia, Justice John Hutchison with the Supreme Court of Appeals of West Virginia, Judge Jane Roth with the Second Circuit Court of Appeals, and finally, Judge Toby Hampson with the North Carolina Court of Appeals. Please stand by, and in just one moment, we will welcome in our judges and have our bailiff call the case.
Oyez, oyez, oyez. All persons having business before the Honorable Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. Judges Gregory, Inman, Kelsey, Byron, Urbanski, Getty, Hutchinson, Roth, and Hampson preside today. God save the United States and this honorable court. Calling the case of Andrew Flight, Superintendent of Wythe Department of Education versus Jack Hart, docket number 2020-0820.
Counsel for petitioners, you may proceed.
Chief Justice, Your Honors, and may it please the court. My name is Malin Maurer, and I, along with my co-counsel, Ms. Sydney Jolliffe, represent the Marshall County petitioners. This time, we'd like to reserve 90 seconds for rebuttal.
So noted.
Thank you, Your Honor. Today, I will be explaining how the Marshall County petitioners' actions against Mr. Hart comported with the Second Amendment, and my co-counsel will be explaining how their actions complied with the First Amendment. And we begin with the Second Amendment to follow the record chronologically. So on that note, this court should reverse the 14th Circuit Court of Appeals Second Amendment holding for two reasons. First, Mr. Hart's sanctioned conduct falls beyond the scope of Second Amendment protections. And second, the Gun-Free Schools Act, the policy under which Mr. Hart was sanctioned, passes constitutional muster under any heightened scrutiny test this court deems appropriate to apply.
Can I interrupt a second? I can't see the speaker.
Okay. All right. I don't know. Maybe we'll get some technical assistance there. Madam Justice Clerk, you will help Justice Roth. We appreciate it.
Yes, bailiff, if you could pause the time for just one moment.
Thank
The
you.
time is paused.
Are you able to see everyone on gallery view?
Yeah. Well,
Okay.
I see 9 people, yeah.
That should be fine. If you can see the speaker,
I can't see
Petitioner?
the speaker. I
who's waving
see,
his hand.
no,
You see someone raise their hand?
no.
Oh, okay.
Since you're on an iPad, it might be necessary to click an arrow and go on to the next screen.
All right, everyone. So clearly we're having just some light technical difficulties. Just one moment while we get everything resolved. We will get Judge Roth back in here as soon as possible.
Thank you.
Thank you. Thank you for your patience, everyone.
Starting audio. Okay, I'm out of gallery view, but I see the speaker.
We good now?
Let's just wait one moment. She's on the phone with the clerk. So we're just going to make sure that we get her resolved with her video.
All right. Okay.
Yes, I'm on an iPad.
Okay, I think we might have Justice Roth back.
All right, great.
All right, so
Yes, I'm back.
wonderful. I would like to, just since we had a little bit of a longer interruption there, I'd like to restart the time if that's okay with the petitioner, so that you all can begin your argument from the beginning, if that's all right with everyone.
It's fine. Thank you.
Okay, great. All right, you don't need to do the oyez again, but Petitioner, you may proceed.
I think we can start with counsel for petitioner proceed.
Very well. Chief Justice and your honors, I was just about to say why this court should reverse the 14th Circuit's Second Amendment holding. There's two reasons why. First, Mr. Hart's conduct falls beyond the scope of Second Amendment protections. And second, Mr. Hart was sanctioned under the Gun-Free Schools Act, which passes muster under any standard of constitutional scrutiny that this court deems appropriate to apply. Now, before I address both those points, I want to just quickly touch on why those 2 points are relevant here. Following this court's decision in Heller, every United States Circuit Court has universally adopted a 2-step approach to analyzing Second Amendment challenges. First, that approach asks whether or not the challenged conduct in question actually falls under the protections of the Second Amendment. If so, you proceed to the second step. However, if this court is to find that Mr. Hart's conduct was not protected by the Second Amendment, the inquiry ends and the Second Amendment challenge must fail. Moving to that second step, circuit courts have adopted a sliding scale of scrutiny approach, asking, depending upon the regulation in question, whether it's more appropriate to apply intermediate or strict scrutiny. Here, our contention is that intermediate scrutiny is appropriate. However, the Gun-Free Schools Act passes muster under both intermediate and strict scrutiny.
Counsel, this is Justice Kelsey. May I ask you this? In terms of your as-applied challenge, does it matter to you one way or the other whether or not Mr. Hart intended to make a display of his weapon as opposed to had no intent whatsoever, no mens rea whatsoever? Does that distinction matter to your argument?
No, Your Honor, for 2 reasons. First, often as-applied challenges to regulations burdening the Second Amendment fail when the sole argument is that the person in question didn't have that intent element. For example, if Mr. Hart had driven his pickup truck to school, the physical school, and forgotten that he left the shotgun behind the seat. In that case, Mr. Hart's conduct is still sanctionable. However, there's also an important factual difference here. As you mentioned, Your Honor, this is an as-applied challenge. Mr. Hart engaged in a series of intentional conduct. He stood up from his computer. He went and retrieved his firearm. He returned to the virtual classroom. He sat back down, and he proceeded to clean and maintain his firearm for approximately 40 minutes. And during that time, students and classmates expressed concerns and messaged Mr. Hart. His teacher messaged him. There was time for the cops to be called. This wasn't just a quick accidental lapse in judgment, absent intent. It was, however, a much longer period of time.
So you really believe he intended to make a display during that entire period, that he actually believed that it was being displayed? What is the evidence of that?
No, Your Honor, if I could clarify, it is not the petitioner's intention that Mr. Hart intended to display his firearm within that virtual classroom via his webcam, merely that he intended to go and retrieve it. The record is clear that Mr. Hart did forget to turn off his webcam's video. Now, that's still an important distinction to make, tracking back to my first point, which is that Mr. Hart's conduct falls beyond the scope of the Second Amendment because Mr. Hart, while in his virtual classroom, that being the parameters and confines of his webcam's view, has less of a Second Amendment right than he otherwise would be just simply sitting in his home. Because this court in Heller announced certain presumptively lawful historical restrictions that have always been understood to fall beyond the scope of the Second Amendment. The sensitive place exception is one of those restrictions.
But
Counsel.
the rationale in Heller, is it not, that for the sensitive place is the protection of people who are at these sensitive places. And that does not apply at all in this virtual setting, does it, counsel?
Physical safety, no, Your Honor. However, there are other compelling interests in this case. But one important distinction I'd like to note, following Heller, because Heller left the inquiry open. Heller said schools and government buildings are sensitive places, but didn't announce that to be the entire limits of the list. So after Heller, the circuit courts have engaged in this discussion of what conduct and what locales can also be considered sensitive places. Turning to the case of class out of the DC circuit.
Counsel, this is Justice Kelsey again. Can you answer Justice Urbanski's question? What makes a virtual room a sensitive place? Don't give cites or legal theory. Tell me factually what makes it a sensitive place. No one can be shot through a computer screen.
Exactly, Your Honor. The dangers here are not that of physical safety. However, the two compelling interests here that make the virtual classroom a sensitive place are, first, the compelling interest in the harmonious facilitation of education coming out of Tinker, and second, the psychological well-being of children, this court announced in Pacifica Foundation. Here, the sensitive place, that being this virtual environment, is necessary to advance both of those government interests.
Mr. Maurer, I think the issue that the court's wrestling with is a problem with the wording of the statute into how do you get a sensitive place out of the statute that reads zero tolerance for students' use of firearms?
Your Honor, the petitioner's contention here today is what the Gun-Free Schools Act prohibits is merely the display of firearms within one's webcam feed.
That's the amendment. That's the amendment that the legislature made to the statute. But didn't they create a contradictory tension when they say that the zero tolerance is for students' use of the firearm, but then also add an amendment that says, well, any appearance makes it a sensitive place?
Your Honor, the Gun-Free Schools Act can't be read in a narrow vacuum, but rather read as a whole. And I simply point to the fact that the entire act itself is just a couple sentences. It's not this long, dense manual students have to, digest and understand. Merely the Gun-Free Schools Act states, first, that the Gun-Free Schools Act extends to the virtual environment, and second, that Mr. Hart's conduct in this case violated that his webcam was displaying that firearm for a prolonged period of time, such that class was disrupted and students were concerned and damaged psychologically by that effect, uniquely in this case, because
Counsel, this is Justice Kelsey again. What if my son drove to school, parked across the street from the schoolyard in a private parking lot, but he had a shotgun displayed in the back of the window of the pickup truck because he's going to go hunting with dad later in the afternoon. And every single school bus that drives by is going to see my son's shotgun in the pickup truck. Would that be covered by the statute? And if it weren't covered by the statute, how can this virtual thing be covered by the statute?
Your Honor, there's an important distinction to be made between the hypothetical you just presented in the record here. That being that the Gun-Free Schools Act doesn't purport to extend to that private parking lot. That's not a school function. That's not the school itself. It's not the virtual format. So the text of the Gun-Free Schools Act doesn't extend to that parking lot.
Well, then how can it extend to my home where I have a shotgun on the wall? If my pickup truck and my son's shotgun is right across the street from everyone driving into school, and it doesn't extend there, my home where the shotgun's up on the wall is subject to the government's restraint?
Yes, Your Honor. In this case, this court must pronounce a rule. And the petitioner suggests this court consider, as Heller 2 did, that being a circuit court case following Heller 1, that certain de minimis infringements and regulation of the Second Amendment doesn't constitute a Second Amendment challenge. Your hypothetical of this gun visible in a pickup truck in a private parking lot as school buses drive by it, at worst would constitute a de minimis sight of the gun. Nothing too extreme that would invoke the sort of distress that Mr. Hart's classmates suffered from seeing his gun, because just a month prior to Mr. Hart's conduct, there was an attempted shooting at a school event that students were still raw from, and uniquely perceptive to the certain fear that comes when they see a gun being wielded. Counsel,
let me ask you this. How does it square with, after Heller, there are things left open, but one thing seems to be without debate, that a gun in your home is protected as a fundamental right under the Constitution. So when you talk about these fears, we all know that domestic violence, accidental gun shootings happen, but the court wasn't concerned about that in terms of whether or not that would somehow limit the right. He's in his home and he has a Second Amendment right. How is that beyond the scope of the Second Amendment under Heller? Home is in his home. So the burden is on you to say there's some carve out. It's not in Heller. Where is it?
Your Honor, you actually bring up a great point there to answer your question. You touched on that notion of domestic violence. Following Heller, circuit courts have upheld the idea that certain dangerous persons, including convicted domestic abusers, can have their Second Amendment rights infringed, including in the home, in certain narrow circumstances. For fear, right, in your example, of that continued domestic violence, especially with a gun. Here, petitioners asked this court to adopt a similar reasoning. That being that in the very limited time, place, and manner restriction of school being conducted in a virtual format, only when a student's on webcam and that webcam is visible, that student be asked simply to not display a firearm.
Well, counsel, let me interrupt just a minute. A minute ago, you were talking about de minimis exposure. And at that point, aren't you turning every inquiry regarding whether or not the Gun Free Schools Act has been violated into a factual question, and it's going to have to be decided on a case-by-case basis? Isn't that what you're telling us we're going to have to do?
No, Your Honor. Allow me to clarify. That de minimis suggestion the petitioners present is specifically cabined to this idea that when there's an as-applied challenge to a regulation, this court, secondarily to the fact of whether or not the right is actually implicated, consider whether the regulation is imposing anything more than just a de minimis restriction. So while it is a fact-by-fact basis, the only cases in which that would actually be necessary to undergo that analysis would already be as applied challenges, as we have here, where the facts are integral to the necessary legal considerations this court must undergo.
One of the factors that you mentioned as important for our consideration is the shooting a month earlier, the shooting incident in the school. But does the validity of the regulation, is that controlled by this one incident a month earlier? Don't we have to look upon the regulation in its overall validity as opposed to the reaction to one incident in the past?
Yes and no, Your Honor. Respondents have pled their case as an as-applied challenge. This court granted cert on that as-applied basis. So while the prior attempted school shooting, or it was a school dance, shooting at a school dance, wouldn't necessarily be relevant to a facial challenge of the Gun Free Schools Act, it is relevant to respondents' as-applied challenge because that situation is uniquely impactful to the harmonious education of Mr. Hart's fellow students and their psychological welfare implicated here, which turns me to my—
counsel, that what you're saying in response to that question is that someone's Second Amendment rights in their home depends entirely and is calibrated entirely to the emotional reaction of those seeing it. That doesn't make any sense. In some cultures, it's not a big deal at all to see a shotgun laying up against the wall. In other cultures, it totally freaks people out. Is the Second Amendment that pliable?
Ordinarily, Your Honor, no. However, petitioners are asking this court to consider those two compelling interests this court has already adopted, that being the interest in tinker of education and secondarily the interest of psychological welfare of children.
Counsel,
this is Justice Inman. You talked about this being de minimis. I certainly don't think Mr. Hart thinks this is a de minimis, right? You would agree there?
Your Honor, allow me to clarify. It is not petitioner's contention that the sanction against Mr. Hart is de minimis, but rather in certain other cases, in response to a justice's hypothetical, where the conduct wouldn't necessarily arise to anything more than that of a de minimis violation, in that set of facts, independent of this case, there would be a de minimis argument. That is not the contention here.
But for somebody who doesn't, it's undisputed that he didn't intend to display this. He didn't intend to display this. And you said that's okay because other gun laws are applied. Isn't this different? And I realize you've run out of time.
Your Honor, I see my time has expired. May I answer your question?
You may answer the question.
Your Honor, yes, this is different, but different such that the Gun Free Schools Act passes that constitutional muster because the record is clear that Mr. Hart's conduct was so disturbing to students and their psychological well-being that class must cease. And when this court engages in those balancing of tests, that's a factor to consider. Thank you.
Thank you, counsel.
May I proceed?
Yes, you may proceed, counsel.
Thank you, Chief Justice. Your Honors, and may it please the court. My name is Sydney Jolliffe, and I also represent the Marshall County petitioners. Schools must be allowed to protect their students and foster a safe and productive learning environment. Certain off-campus speech, such as respondents, which threatens to instigate gun use in schools, can disrupt this vital mission. This court should reverse the 14th Circuit's decision and find that Marshall County High School permissibly regulated the respondent's speech under the First Amendment for the following 3 reasons.
Before you get started on that, did you say this speech threatened to instigate gun violence in schools? Is that what you said?
No, Your Honor. Threatens to instigate gun use in schools.
So these comments are threats to fire weapons inside the school building? Where's the evidence of that?
Your Honor, the respondent in this case liked a comment that said to arm students and teachers in schools with #ArmTheSchools. In the totality of the circumstances.
But obviously what that's being said there is there should be people in the sensitive areas, probably not students, who are armed. I mean, that's a public policy debate. That's very different from saying that they're saying people should go in and start shooting people in a school.
I agree, Your Honor. It is different. And it is a valid public policy stance and one that's being hotly debated in most rungs of our government. However, in the totality of these circumstances, with Mr. Hart being involved in a prior instance of using a gun on camera during class, Mr. Hart's conduct on social media led to a disruption in the school community, and it foreseeably did so.
Counsel, are you arguing in response to Justice Kelsey's question? Are you arguing that that the comments that were made, the liking of the various posts, constitutes a true threat to the school or to the children that attend the school?
Your Honor, while the petitioner's contention today is that is not that the true threat test should be applied in this case, this conduct does satisfy the true threat test. The petitioners are arguing that Tinker be extended to situations such as these where students' conduct off campus is foreseeably or can foreseeably affect and disrupt the school community. However, I can address the true threat test in that the true threat test stands for whether or not an objectively reasonable person would interpret the speech as a serious expression of intent to cause a present or future harm. Now, that's an objectively reasonable test. However, here we don't have to work in hypotheticals. An objectively reasonable fellow student discovered Mr. Hart's posts on Picogram and was threatened enough by them to report him to the school. So it does.
Jolliffe, these aren't Mr. Hart's posts. These are likes. Don't you think there's a big distinction between liking something by just clicking a button in a computer and then adhering to everything that's in a particular message? What cases do you have that support your position?
Your Honor, a few cases below have recently decided that a like on social media does amount to protected speech under the First Amendment. Those cases, a few of them are Bland versus Roberts from the Fourth Circuit and Shen versus Albany Unified School District from the Northern District of California. They use the standard dictated by Spence versus Washington that says that protected speech must demonstrate an intent to convey a particularized message. In this case, a thumbs up or a heart, a like on social media is a universal sign of approval for that message. And while it can be argued that someone might like a post simply to follow it, that person is leaving a permanent record on social media that they have decided to follow that post, and that they're putting their own mark on it. In this case, Mr. Hart's likes of the post on Picogram haven't been disputed in the record as being accidental. Mr. Hart, there's no evidence in the record that shows that Mr. Hart doesn't support the content of the messages.
But,
and
as to, in this instance, this is as applied, he's responding to his case. It started with his father. A child is supporting his father's position about his case. As applied to him, you say this statute says no negative comments. This is not a facial challenge, but as applied to him, why can't he garner support to help him reverse his suspension?
Your Honor, it is not our position today that Mr. Hart is not permitted to engage in discourse about his punishment or his Second Amendment rights. That activity online, however, can be regulated when it is foreseeable that it will cause a disruption to the school community, as it was here. Mr. Hart was at the center of this controversy.
Wait a minute.
And
Wait a minute. Hold up,
What is
counsel.
this? I'm sorry. Go ahead.
No, go ahead, Justice.
Well,
My question is, what is the evidence of the specific and significant disruption? That's a quote from Tinker. It says, may prohibit student speech only by showing a specific and significant fear of disruption. So what does the record tell us with regard to that specific finding? You're relying on Tinker. So what is the specific finding that would support your position with regard to clicking a like?
Your Honor, the record on pages 5 and 6 show the disruption to the school community in two ways. First being that Mr. Hart, by liking a post advocating for blasting school administrators with emails and letters, caused school administrators to deal with hundreds of emails and letters a day. Now,
So hold up. So someone doesn't have a First Amendment right to say, look, I want you to write the government official who I think is treating me improperly. I want you to write emails. I want you to petition them. They didn't say blast them with shotguns. They said blast them with free speech. Isn't that the heart of the First Amendment?
Yes, Your Honor. You actually are hitting on my next point. Now, Mr. Hart is able to engage in discourse about his punishment. He's able to criticize the school and fight against his punishment. However, taken together with the second part of the facts here that of the disruption is that Mr. Hart was at the center of an ongoing controversy involving gun use in schools.
But it seems to me that though you say that he can try to garner support, but it seems like you're also trying to push him back into the 20th century. The only way kids today try to garner support is by going on social media. And it seems like any type of social media presence or comments may get back to the school. So tell us, how can you possibly as a student use social media without running afoul of this policy?
Your Honor, Mr. Hart, while the petitioners recognize that the digital age brings more connectivity, it also then brings more opportunity for that connectivity to cause disruptions to the classroom. Mr. Hart, again, was able to go online and protest his punishment. However, when that activity is foreseeable to cause a material disruption to the school community, that is when the school gets involved. And in this case, parents and students were writing into school administrators talking about how they were concerned about Mr. Hart's behavior because of his prior instance of bringing a gun on camera. It also goes to the reasonable foreseeability that this would have caused a disruption in that in the prior instance that my co-counsel brought up of the Valentine's Day dance, a school shooting was prevented because administrators caught the person online talking about how they were going to come and shoot their girlfriend at the dance. Mr. Hart had
Counsel,
notice.
Yeah, thank you. You know what? I'm sorry, I've lost my train of thought.
Mr. Hart had sufficient notice to know that he was that his social media was being monitored by the school and it could cause a disruption in the school community.
I'm back. So the policy here, the policy here expressly prohibits the sharing of negative information. What evidence in the record here is that it was the result that there is a causal relationship between Mr. Hart purely liking a post and that making it more visible or publishing that threat to the public?
Yes, Your Honor. While it's almost impossible to argue that Mr. Hart's like alone affected the number of people reaching out to administrators. However, the reason why parents and students emailed into administrators and contacted administrators regarding their concern with Mr. Hart's behavior was because Mr. Hart specifically liked it. Not the content of the post, but because it was him who liked it and him already being at the center of a controversy involving gun use in schools.
So you've twice now mentioned this linkage between Mr. Hart and the posting. Would you agree that therefore it would not be a violation if it was just another person and not Mr. Hart who liked the one of these social media posts?
Yes, Your Honor. The petitioners would say that. It is because it was Mr. Hart, and when analyzing the facts as a whole, because it was Mr. Hart who liked the post, that is the reason why it was a disruption, and that is why Mr. Hart specifically was punished for it.
Counsel. Ms. Jolliffe? Oh, sorry. Ms. Jolliffe?
Yes.
You keep emphasizing, the import that it was Mr. Hart who did this. He's also the person with the constitutional right he's defending, his Second Amendment right. You've given a lot of reasoning, but are there any cases in which the student who's been held responsible for and not have a First Amendment right to counterpose discipline for something like this on social media has been doing it to defend their constitutional right?
Your Honor, while no specific cases regarding defending other rights come to mind, there are several circuits below where there have been cases where Tinker has been extended to student speech where they are trying to defend their First Amendment rights to that speech. And in those cases, in those circuits, 5 of the 6 circuits besides the 14th that have addressed the issue of whether Tinker can apply to that speech have found that it does. And this is because of that increased connectivity in the world that we live in today. The Tinker standard was first promulgated in order to protect that classroom learning environment. And with this increased connectivity, there's more opportunity for student speech online to then affect the school community. And those
isn't student speech online part of that learning experience?
I apologize.
Isn't student speech online part of that learning experience? Do we want our students only to hear a very bland type of discussion which doesn't get into any controversial issues?
No, Your Honor, we do not want to restrict students' ability to engage and learn online. However, this case is unique in that Mr. Hart's speech caused a disruption to the school community. Rather than furthering the learning of the students around him, they caused them to fear for their classroom learning environment and then disrupted their vital interest in learning rather than furthering it.
I'm really struggling. I'm sorry, go ahead, Justice Rowe.
No, go ahead.
I'm really struggling with the difference for First Amendment purposes with someone who likes it versus Mr. Hart who likes it. I don't understand how that can be, there can be any meaningful distinction under the First Amendment.
Your Honor, if I'm understanding your question correctly, you're asking why Mr. Hart, may I briefly finish answering?
No.
Thank you. I believe you're asking why it was specifically Mr. Hart who was punished for this. If you're getting at like the proximate cause of the issue and the disruption. In this case, again, it was not the content of the speech that's being regulated. It is the fact that Mr. Hart, being already at the center of a controversy involving guns in schools, liked the post, and that is what caused the disruption. Thank you.
Thank you, counsel. Counsel for the respondent, may proceed.
May it please the court. My name is Kylie Terry, and along with my co-counsel Javier Gonzalez, we represent the respondent, Jack Hart. We respectfully ask this court to affirm the judgment of the 14th Circuit Court of Appeals in all respects. There are 2 issues. My co-counsel will address the free speech claim, and I will address the Second Amendment issue regarding the Gun-Free School Act, or the GFSA. The GFSA violates the Constitution for 2 reasons. First, because the home is not a sensitive place, and second, because the act fails intermediate scrutiny. Now, before I get to my first point, I'd like to address 2 things. The first is that the GFSA prohibits the visibility of guns on camera. But on page 2 of the record, it makes clear that a student must remain on camera at all times. This is an effective ban on the ability to bear arms in one's own home. The second is that Jack Hart is a senior and an 18-year-old at Marshall High School.
Counsel, does the GFSA actually ban the owning of guns in one's home?
No, Your Honor, it does not. But
does it require that any weapon in a firearm in the home be rendered inoperable?
No, Your Honor, it doesn't.
So, so from that regard, how does the mere prohibition on the visibility of guns, does it in fact prohibit a student from having a weapon or a firearm on their person?
No, Your Honor, not at all. It doesn't prohibit Jack Hart from having a firearm in his lap, holding a firearm, or even having it right next to him and looking at it the entire class.
Is there any prohibition on a student using a weapon in self-defense?
It does, yes, Your Honor. That's where the GFSA steps in, is that if a student were to ever use the gun on camera, then the GFSA prohibits that behavior. Here, Jack Hart can hold it and have it in his lap, but that's not what the Second Amendment protects. It protects his ability to actually use that gun, and Jack Hart never has that ability because he has.
But Ms. Terry, here, under these facts, he wasn't defending himself, right?
No, Your Honor, he was not.
He wasn't defending himself. He could have been doing all the things you're talking about, and that's not this case, right?
That's correct, Your Honor. And this is an as-applied challenge. So we do have to look at the facts here. And the facts here, Jack Hart was making sure that his gun was in proper working order. He wasn't brandishing it on camera. He wasn't threatening other children. He was ensuring that if the need arose for him to defend himself, he did have that ability. As on
Ms.
page
Terry, let's look at the actual language of the statute. When I asked opposing counsel about the language, they turned to the amendment, and you've stressed students' use in this argument, but from the amendment, use doesn't have anything at all to do with Mr. Hart's infraction. The amendment says students may not have any weapon visible on camera.
That's correct, Your Honor. Here, Jack Hart is essentially defenseless under the GFSA. Even if he was not actually using his gun at the time that he was disciplined, he still has the right to ensure that his gun is in proper working order.
Well, then all he had to do, counsel, is cut the video off and shoot the burglar.
That's true, Your Honor. But on page 2 of the record, it makes clear that there is some kind of catch-22, that a student has to have their camera on at all times.
I'm sure if there was a burglar coming through the front door and he was poised to use his Second Amendment right, he wouldn't be worried about the quiz that he's taking in algebra class.
Maybe not, but the GFSA would regulate that behavior. So if Jack Hart was not worried about the GFSA and did lift his firearm on camera, he would be in violation of
But the problem I don't get is the question that Judge Inman asked you. That's not our case. It'd be a whole different thing if he was caught in a firefight with some sort of robber and some incredibly over-the-top school administrator wanted to nick him on some school disciplinary thing. I mean, that's not our case, right?
That's correct. And in District of Columbia versus Heller, this court made clear that there is still a right. The right does not just extend to being able to actually use a gun when you're in a dangerous situation.
Counsel, you said that this is not a sensitive space, but this act arose from COVID-19 and the threat to all of us and trying to continue public education. And in that, they said the solution would be virtual learning. And with that, like everything, requires some level of cooperation. That is to provide time and space. The time is the school time, and the space here is someplace conducive to learning. The only prohibition is that the gun cannot be visible within the view of the camera. That doesn't restrict almost any place in the home, but for that little narrow, which can be controlled and made even narrower. How could that possibly, in terms of as applied, impact him? Because he can't clean his weapon during school time?
Your Honor, it does impact him because it leaves Jack Hart defenseless. He cannot use his weapon, cannot hold his weapon, cannot ensure it's in proper working order. And that's what was happening in this case, is him ensuring that his gun actually worked if he did need to defend himself. On page 2 of the record, he has to remain within the camera's view. So while it might not restrict the entire home, that he might not have to point his camera to every area of his home and there could still be guns in other locations, he cannot ever actually show that gun on camera, which is what would happen if someone came into his home. He would not have.
And if he were at school, he would not be able to clean his gun so that if someone invaded his home, when he got home, he could shoot it. But I mean, that is something that he just has to forego because of the needs of security of the school.
Your Honor, it's true. If he was at school, he would not bring a gun. He would not have a gun anywhere near him, but he would also have the protections of the school. It is a well-known fact that when a student is at home, they have lost all safety of the brick and mortar school. There are no security guards. There is no one there to protect a child if something were to happen.
What level of scrutiny do you believe we should apply in this case?
Your Honor, in this case, strict scrutiny is the appropriate scrutiny because this is not a sensitive place and it's not a minimal burden on the right.
Isn't this, though, the least restrictive alternative that could be applied?
No, Your Honor, it's not. There is an easy alternative, and that alternative is to allow students to simply turn off their camera, not right before there is a burglary or a break-in, but just if they have a need or feel like they would need to defend themselves. In Duncan versus Becerra, this is what the California District Court found, is that there was a law that prohibited having a large capacity gun magazine. They said that that law was not narrowly tailored because it didn't make exceptions for people who had actually had a break-in, people who were fearful of a break-in, or people who lived in densely populated areas. Here from the record, it's clear that there have been break-ins in Jack Hart's neighborhood, specifically because of COVID. So while Jack Hart has been pushed into his home to attend school, and the school is trying to regulate that area now, he is less safe. So while they contend that they are trying to put forth safety as their means or as their end to achieve this, or as their end of the GFSA, they are actually undermining this goal because Jack Hart is defenseless in his own.
Counsel, what part of the weapon was he cleaning? Was he cleaning the barrel or was he cleaning the firing mechanism?
Your Honor, he actually wasn't cleaning the weapon at all. On page
Okay, well then why are we talking about that?
Well, Your Honor, on page 2 of the record, it says that Jack got his water, retrieved his own shotgun, and checked to ensure the gun was in proper working order. So it's unclear exactly what he was doing, but he was making sure that his gun was prepared if he did need to use it. Now here, even though Jack Hart is in school, this is not a sensitive place because it's virtual school, and this court has never held that a virtual platform could become a sensitive place. In District of Columbia versus Heller, this court made clear there are sensitive places where the regulation of guns is presumed lawful, and those places are schools and government.
Counsel, I can't think of anything more sensitive in a school which had just had a gun incident 2 weeks before to have a classroom with children and have another child with a firearm. I can't think of another place more sensitive. Certainly it doesn't square within the facts of Heller, but isn't this just as sensitive a place as Heller? It's just so virtually.
It's not just as sensitive as the place in Heller. This court has never held that psychological safety contributes at all to the sensitive places analysis. While
but shouldn't it? Shouldn't it as a matter of public policy? I mean, these are children we're talking about.
Your Honor, it shouldn't extend because in this case, a sensitive place is a physical location where one is actually in danger and is defenseless. In this case, students could just simply look away from the camera and
this was dangerous enough that the teacher called the police. I mean, this was dangerous enough that some other children were upset by this.
Your Honor, to be clear, we agree that the state does have a compelling interest in protecting the psychological safety of children. The problem here is that psychological safety has no bearing in the sensitive places analysis. This court and no other court has ever held that psychological safety could render a place a sensitive place where the regulation of guns would be lawful. Here,
but shouldn't this court do that? I mean, shouldn't this court do that?
No, Your Honor, this court shouldn't. And it's because Jack Hart is unsafe in his own home. He is not able to defend himself. And even though there are other children on the other side, there are ways to make this law more narrowly tailored. And that brings me to my second point, that this law does not survive strict scrutiny. Under strict scrutiny, the government must have a compelling interest, and the means must be the least restrictive means. Now here, I've already stated one way that the Gun-Free School Act could be more narrowly tailored. The Gun-Free School Act could simply allow a student to turn off their camera. In United States versus Marzarella in the Third Circuit, they found that the law prohibiting guns that had the serial number scratched off of it was lawful as a time, place, or manner regulation.
Counsel, your client didn't even know the camera was recording him. The thing I don't understand about your argument is the very thing I asked your opposing counsel. Doesn't the fact that mens rea is not being imported, as it always is under common law, into statutory provisions unless there's a rebutting principle, doesn't that mean that intentionality is relevant? But you make nothing of the fact that this was completely accidental and he was not intending to do any of the threatening things that the psychological vulnerability of the children were observing. But I didn't read in your briefs, and I'm not hearing you say a thing about the fact that there was zero intent at all. This is a strict liability crime.
Your Honor, that's true. Jack Hart had absolutely no intention. He was of threatening other children or of even harming them by showing a gun on camera. This is a strict liability crime, and that's one way that it could be more narrowly tailored, is that the Gun-Free School Act could simply prohibit threatening use of guns on camera.
So what I'm saying is, why isn't your argument that, look, whether or not you knowingly put a gun in front of the camera is a Second Amendment violation, for sure. If you don't knowingly do it, you didn't even know you've done it. That is a completely different case, and the Second Amendment rights should supersede.
Your Honor, that is a portion of our arguments, that's one way to make it more narrowly tailored. But the other part of this argument is that he is required to have his camera on. So whether he knew he was on camera holding a gun or not, he does not have the right to do so. So his intention in this case is not very relevant because he has to be on camera and he can never show the gun on camera.
Counsel, wasn't he required to be on camera because it was a pop quiz? Not always. It had to assure that he was not receiving inappropriate assistance during the pop quiz. There's nothing in the facts that say you're required to have it on all the time during instruction, is there? Am I misinformed?
Your Honor, I believe on page 2 of the record, it states that the school does have a policy that requires students to be on camera. So,
but counsel, your argument is focused on this Gun Safety Act. Your argument seems to be more of a collateral attack on the school board's policy or the school policy of having their cameras on. So it seems that perhaps that remedy is directed at the wrong place.
Well, Your Honor, these go hand in hand because Jack Hart was punished for him using a gun on camera, and the Gun-Free School Act could simply allow for students to turn their camera off, or as Justice Kelsey said, it could have simply prohibited threatening behavior of guns on camera. Now here, the school is contending that because of a global pandemic, they are now able to regulate the insides of every student's home who goes to their high school. That is not what the Second Amendment allows for. The Second Amendment allows for a student to be able to defend himself when he's in his own home. Because of a global pandemic, it is a well-known fact that crimes in Jack Hart's neighborhood and crimes all over the US have increased, and Jack Hart has now lost the physical safety of the school and he is rendered defenseless.
But counsel, doesn't instruction distract him from being able to defend himself too? That you would take without limitations of your argument, you would say, well, you can't really engage in any instruction that intense because a burglar may come in and I won't hear that person.
Your Honor,
is there?
I see I'm running out of time. May I answer your question?
Yes.
Your Honor, Jack Hart may be distracted from a burglar who comes in, but Jack Hart wants to learn and he does have the right to learn, but he also has the right to keep and bear arms in his home, and he's completely lost one of those rights. He's not just distracted from the ability to bear arms in his home, he's actually lost that entire right. And it's for these reasons that we ask this court to affirm the judgment of the 14th Circuit Court of Appeals in all respects. Thank you.
Thank you, counsel. Mr. Gonzalez?
May it please the court. My name is Javier Gonzalez, and I also represent the respondent in today's case, Mr. Jack Hart. The judgment from the 14th Court of Appeal should be affirmed for two reasons. First, Tinker does not extend to off-campus speech. And second, even if it does, there is no substantial disruption in this case. Now, Your Honors, before I enter into my argument, I'd like to address some of the things that Petitioner mentioned. Specifically, in her opening, she said that Jack Hart was seeking to instigate gun use in school and that a student had discovered these posts and had felt threatened. However, none of that is actually in the record. The post that was liked by Jack Hart specifically says that if students and teachers could be effing armed, we wouldn't have a mass shooting in schools problem to begin with. Now, that is a far cry from instigating gun use and gun safety issues at school. And furthermore, the post that was found by one of the students, nowhere does it say that he actually felt threatened. And that goes more to the substantial disruption standard. But at this point, Your Honors, Tinker has not been found to expand to off-campus speech.
Can I ask you about that, counsel? So suppose he didn't say what I didn't like a post like this, but he liked another post, and the other post actually did constitute a true threat under Brandenburg's theory. You're telling me that that couldn't be something that a school administrator could not take into account when it's a threat against the school and issue some reasonable disciplinary response to it?
Your Honor, the school board would absolutely have the right to regulate that true threat because true threats are not protected under the First Amendment. Even taking that true threat into context with the other speech, you would have that true threat that would essentially overturn or overpower the non-true threat elements of the speech, but we don't have that here.
But is this really speech? All he's doing is liking something. Is this speech protected? Is it protected speech under the First Amendment?
Your Honor, it is. Although it might not be pure speech, it is still substantive speech, as the Fourth Circuit found in Bland versus Roberts.
Mr. Gonzalez, haven't other circuit courts held that off-campus speech has, in fact, come within the scope of Tinker?
Yes, Your Honor. In fact, 5 circuits do find that Tinker can apply to off-campus speech, but the most recent circuit to deal with this question, the Third Circuit in BL versus Mahanet, found that it did not. And in fact, it relied on more recent precedent from this court, from Packingham versus North Carolina, where this court said that the new public square is the internet. Taking that into account, the Third Circuit correctly found that the test applied by lower circuits just simply encompasses too much protected speech. And in fact, if we take examples from this court, specifically in Bethel versus Frazier and Morris versus Frederick, this court said in Morris versus Frederick that the speech made in Bethel versus Frazier, where a student was using lewd, obscene sexual innuendo at a student assembly, would have been protected in a public square. And that lends credibility and lends precedent to this court finding that Jack Hart in the new public square expressing those ideas cannot be regulated by the school board. And that's because
here the speech, as it were, and is all referring back to an incident that occurred not in the public square, right?
Correct, Your Honor.
Occurred in a special place with a limited audience.
That's correct, Your Honor. It's referencing an act that did occur in a special place with limited audience, but the speech was not. And that's the key distinction here. Although he was in class when he did show a gun, that speech was not in class time, was not on school grounds or school property. With this argument, essentially, Petitioner is arguing that a student is a 24/7 student. Even if the bell rings at 4 o'clock, anything he can say afterwards can still be regulated by a school. And that simply expresses too much latitude for a school board to use. Because the main concern of Tinker from this court was that a student's right to free speech not overpower another student's right to learn. And that's where this court decided the two tests. If there's either a substantial disruption or a reasonable foreseeability of a disruption, then the school board with on-campus speech can go and regulate that speech.
Counsel, did you just disagree with your co-counsel? Your co-counsel was arguing under Heller that this is not a special place. And you, in response to your question with Justice Inman, indicated that the virtual classroom is a special place. Your Honor, so are you agreeing with your co-counsel on the Second Amendment issue?
Your Honor, to be clear, I do agree with my co-counsel on the Second Amendment issue. It was not a sensitive place, excuse me. But in response to Justice Iman's question, it was a more limited audience. It was in this time that was school going on, but that still does not make it a sensitive place. Now, turning back to Justin Bryan.
Yeah, what I wanted to ask you about is if someone off campus, if Mr. Hart had, in trying to overturn his suspension, encouraged students, and others, not just to send emails, but had said, block access to the school so the administrators can't get in, or if he off campus had really encouraged a substantial disruption, why wouldn't the administrators be able to get at that, even if it wasn't a true threat?
Your Honor, it would depend if this court finds that Tinker does apply. And the problem is that if it does find that Tinker does apply, it's just too much latitude, but it should be limited to allow for those circumstances to be regulated. And at this point, it just isn't regulated enough to where free protected speech is protected by the First Amendment, and the school still enforces its interest in preventing those kinds of blockades. Now, here on the record, we don't have that kind of blockade occurred, and we don't have the level of substantial disruption that Tinker would necessarily require. What Tinker said a substantial disruption essentially means is that one student loses their right to learn or is distracted from school. But we don't have that evidence here. All we have is that the administration received some emails, and then there's some concerned parents and students. But those concerns, as Petitioner actually pointed out, is more about the physical safety of the school campus when there is no school campus to go to. As of now, the school is in a virtual format, and essentially Petitioner's arguing that because Jack Hart was the center of the controversy, that at that point, he also lost his First Amendment right to speak on the matter.
Counsel, you have just referenced physical safety again. Both you and your co-counsel seem to suggest that this court ought to have no regard whatsoever to the psychological safety of students. And we know in this case, when you're talking about disruption, that at least one of Mr. Hart's classmates saw the post and alerted the school officials about it. Should we not be concerned with the psychological impact on our children?
Your Honor, this court certainly has an interest in the psychological impact of the children, but the question is, at what point does that overpower a student's right to speech outside of a school campus? If this was on campus, if Tinker would have been applied to where Jack Hart was disrupting the actual class day to day, at that point, there would be a stronger argument for Petitioner, but we just don't have that here.
Counsel, what does the record say about the kid that turned him in?
Your Honor, the record...
Was he actually psychologically stressed, or was he just a kid that giggled his way into turning an enemy into the principal and ultimately to the cops? I mean, what do we know about that, or anything?
Your Honor, it's on the record on page 5. It says one student at Marshall High School screenshotted the photos and comments that Jack liked and sent the images to the school board. Now, nowhere in the record does the language that Petitioner suggests that he felt threatened appear because of those likes, and that goes to the substantial disruption analysis. There isn't that student who has a psychological harm, who has this right to learn, being taken away, and that's why there's no substantial disruption. Now, even if we apply some of the Tinker tweaked analysis that lower courts use, for example, the sufficient nexus test.
So who has the burden of proof on substantial disruption, you or the government?
The government, Your Honor. The government, the school board has to prove that because of Jack Hart's speech, some substantial disruption occurred. And not just any disruption. It has to rise to the level that another student essentially does not have the right to have a good learning day at school.
Well, then summarize it very briefly. What is the best evidence your opponent has for kids freaking out seeing that weapon? What is the best possible evidence, whether you agree with it or not? What's their best fact?
Your Honor, to be clear, the weapon in the Second Amendment issue or the speech in this First Amendment issue? Your Honor, you're muted.
The speech.
Your Honor, the evidence, the only evidence Petitioner can point to is on 5 and 6 that shows that teachers, students, and parents voiced concerns and that the teachers received emails. At that point, that's
it?
That's it, Your Honor. There's no substantial disruption that this court would typically require to show that that kind of right of another student was infringed upon. Now, if we look at some of the tests that other circuits use, for example, the reasonable foreseeability test or the substantial nexus test, as the Third Circuit pointed out in BL versus Mahoney, those two tests simply encompass too much protected speech. In BL, there is a cheerleader who tried out for the cheerleading squad and didn't make the team. She went onto social media and said, F the school, F the cheerleading team, F the cheerleading captains. And at that point, she was disciplined. Then when she brought this First Amendment challenge, the Third Circuit correctly pointed out that that was protected speech. Even though it was a nice speech or it would have not favorable speech, that speech is still protected under Tinker. And one of the main concerns of Tinker is that a school board cannot regulate speech simply because they disagree with it or because it is lewd or inappropriate speech. Even if we go towards Bethel versus Fraser, where that kind of speech was used on campus, it's still confined to that on campus because the only audience in that instance was the school. Here we had Jack Hart at the new public square telling other people, Justice Byron, as you pointed out, to advocate on his behalf. It's no different than asking my neighbor to call my congressman when I want a law changed.
Do we have to overrule Morse to agree with you?
Absolutely not, Your Honor. And the reason behind that is because Morse's finding is limited in two ways. First, although it was off campus, it was still during a school-sponsored event where the principal had actually let off time so that the students could go see the Olympic torch rally where there was that Bong Hits for Jesus banner. And second, even though that was found to be allowed to be regulated because it advocated illegal action, we don't have that here. We don't have Jack Hart advocating to actually bring a gun to school and shoot up the school, as Petitioner would point him out to be. This blasting talks about him calling to action other people to advocate on his behalf because at the end of the day, he's an 18-year-old senior at a high school. He had his Second Amendment rights violated and the school was ignoring the Constitution. At that point, he asked his friends, the group that he was a part of, to help advocate on his behalf so that that right not be infringed upon. Not the Second Amendment right and not even his First Amendment right, but the school board. Judge Hampson.
Counsel, how much deference here should we give to a school board, a local policymaking body here who understands the context in which these statements are being made, the environment these are being made, and the potential impact these statements are going to make? You know, as a judicial body looking at this on a cold record, how much deference should we give to the local board here?
Your Honor, in fact, this court has recognized that they do give a lot of deference to the school board, but that deference does not allow them to abuse their discretion. Because at this point, what they say would have been reasonably foreseeable to cause a substantial disruption just isn't in the record here. And in fact, there isn't a substantial disruption that actually occurred as far as the record goes. We have
Mr. Gonzalez, isn't there a policy argument, as Justice Hampson has alluded to? In your opening argument, you say the internet is the new public square. Well, obviously, that's where students are communicating and congregating. Are there policy reasons for expanding Tinker just because of what you've argued to us today?
Your Honor, there's certainly some policy reasons, such, for example, a student might be getting harassed by another student online, and that can make it onto campus. But the problem here is that the social media policy used by the school to discipline Jack Hart is just simply too overbroad and gives the school too much discretion. Specifically, if we look at the first sentence, it says students must at all times respect their school, teachers, and other school officials and fellow students. Then the last sentence is even worse. There will be no tolerance for any negative information shared about the school. Now that simply just gives the school board too much discretion to determine what actually causes a substantial disruption.
You're not making a facial challenge, are you?
No, Your Honor, it is as applied, and we do look at what was actually said.
You know, yourself there in terms of the text itself.
Well, Your Honor, if we look at the email that was used to inform Jack Hart that he was disciplined, it says that it was shameful and disgraceful social media posts. Now, that doesn't say that it was threatening language. It doesn't say that he was targeting another school or even targeting the school campus. It just says that the school board did not like that speech. And for those reasons, this court should affirm the 14th Court of Appeals. Thank you.
Thank you, counsel. Counsel for the petitioner, you have some time reserved.
Yes, Your Honor. Just two quick thoughts on rebuttal. First, petitioners cite that the internet is the new public square and therefore it can't be regulated. But petitioner's metaphor forgets its roots. The case held in Morse was that a student that literally stood in a public square and targeted a school with a speech could be regulated after that speech led to a disruption. Now, quoting from Tinker, conduct by the student in class or out of it, which for any reason material disrupts the classroom or involves a substantial disorder or invasion of the right of others, is of course not immunized by the Constitution and therefore it can be regulated. Turning to the Second Amendment, I just want to clean up the analysis a bit because it's a complex issue. Assuming for argument's sake that this court rejects the sensitive place analysis, this court then proceeds to the sliding scale that the circuit courts adopt post-Heller, either to analyze the Gun-Free Schools Act under intermediate or strict scrutiny. But under either level of scrutiny, the respondents have conceded the school has a compelling government interest, that being the psychological safety and well-being of its students.
Was there any evidence, counsel, that any student had psychologically reacted poorly to these images?
Yes, Your Honor. There was a series of messages that resulted following Mr. Hart's display of the firearm to Mr. Hart. The teacher called the police. There was a national news story and disruption after the fact.
No, I'm not asking if did people shout and holler and complain about it, but was there any real evidence of psychological trauma or anxiety?
Yes, Your Honor. The district court did base its findings upon that when it granted summary judgment.
Okay, thank you.
All right. Thank you, counsel. We appreciate your arguments. Clerk, you may adjourn the court, recess the court.
All right. Hello, everyone. Thank you for your argument. Thank you to our panelists. At this time, we are going to have the clerk move the judges into a breakout room for final deliberations and voting. Competitors, at this time, you and your coaches can log off and leave the Zoom room and join us on the live stream for the award ceremony beginning in approximately 5 to 10 minutes. Thank you all. We'll see you soon. And if everyone here can just wait one moment. Alrighty, and everyone in our audience, please stay tuned. We're going to start the award ceremony in approximately 5 to 10 minutes, so don't go anywhere. All right. Hello, everybody out there. I just wanted you to know that we are still waiting for judges' deliberation. We had a very close round, clearly. So if you all can please just stay tuned. We haven't forgotten about you, and there are no logistical errors going on. We just still need a few more minutes to finish deliberation. Stay tuned. Alrighty, welcome back, everyone. We have officially finished with deliberations from the judges. So I would like to get everything started with a quick welcome. So good afternoon, or in this case, good evening to our competitors, coaches, esteemed judges, and friends. We are so honored that you are here. If we haven't met yet, my name is Heather Pearson, and I am this year's Spong Tournament Justice. On behalf of William & Mary Law School and the William & Mary Law Moot Court team, I'd like to officially welcome each of you to the State of With in the 14th Circuit and the award ceremony for the 50th Annual William B. Spong Jr. Moot Court Tournament. This year's tournament, we are excited to have hosted 50 teams from 36 different schools across the country. To our judges, I feel like saying a simple thank you is just not enough. To our veteran judges, thank you for returning to help us continue to make this tournament a success every year. To our new judges, welcome, and thank you for joining us. We hope to see you in person next year. We know each of you are extremely busy and appreciate your willingness to take the time and help us as law students to sharpen our advocacy skills. Your thoughtful questions challenge each of us to think and argue creatively and critically. As we continue forward in law school, your influence will help each of us become better advocates for our clients and better citizen lawyers to lead our communities. To our coaches, the same applies to you. We learned so much from you as you help train and mold us into better advocates. You always challenge us to think quickly, react confidently, and think outside of the box. And if you are anything like our coach, Professor Jennifer Franklin, your team is very lucky to have you and appreciates your time and commitment to them. To our competitors, first and foremost, as one Zoom School of Law student to another, congratulations on completing this tournament and persevering through law school during a very trying time in the world. Last year, if you would have told me that we would all be attending law school remotely and competing in moot court tournaments virtually, I honestly do not think I would have had words to respond. The path that brought you here today has probably not been easy. You've researched for hours and hours, and during your holiday break, nevertheless. You've written briefs full of creative arguments, persuasive analysis, and so many citations. You've taken hours to practice your arguments, trying to get ready for every off-the-wall question that may come your way. And for some of you, you still got hit with the curveball, but I'm sure you hit it out of the park. You each have accomplished so much in such a short time and should be very proud of yourselves. With that being said, this weekend has been full of zealous advocacy. Both Jack Hart and the Marshall County petitioners are lucky to have such excellent attorneys. And although you have to wait a bit longer to find out who prevailed in the case, I want to personally say that I am very impressed with each team and am happy that I do not get a vote. Before we begin, I would like to recognize the dedicated group of my fellow colleagues who have worked since last summer to make this virtual tournament a success. Elle Perfacci served as this year's tournament assistant. Corey Chickowitz was our judge's assistant. Gabby Bohannon was our team's assistant. Daniel Bruce was our logistics assistant, or better known on Instagram as the Zoom master. And Hannah Merrill was our awesome scoring assistant. I would also like to thank our Chief Justice, Alexis Rodas, and our faculty advisor and coach, Jennifer Franklin, for their unwavering support. Without each of you and each of your time and commitment, this tournament could not have happened. All right, everyone, our awards reception is just getting started. First, we will introduce the winners for Best Oralist and Best Brief. Then we will introduce you to this year's Spong Award recipient and the chief judge of this tournament, Judge Roger Gregory, who will then announce the champion and runner-up of the 50th Annual William B. Spong Tournament. So let's get started. I am happy to introduce our tournament associate, Elle Perfacci, a 2L here at William & Mary. Elle will introduce our sponsor, Elliot Buckner from the Virginia Trial Lawyers Association.
Thanks, Heather. It is my pleasure to introduce Elliot Buckner to present the awards for Best Oralist and for Best Briefs. Mr. Buckner is a William & Mary Law School graduate and an alumnus of our moot court team. He is a partner at Bright Cantor Grana Buckner and is the president of the Virginia Trial Lawyers Association. The VTLA is a voluntary bar association established in Williamsburg in 1959, dedicated to enhancing the knowledge, skills, and professionalism of trial lawyers, and is committed to improving the law and the fairness of Virginia's system of justice. The VTLA is a dedicated supporter of our tournament, and we are so grateful they have sponsored the Spong tournament once again this year. Please join me in welcoming Mr. Buckner.
Thank you, Alan. Thank you all so much for participating. It's amazing that this is the 50th anniversary of the Spong tournament, and VTLA is once again so proud to be a participating sponsor in the tournament. It's such a vital and important tournament, as is all of the other engagements that you all are in during the year. As we've seen so much, particularly over this last year, advocacy is important because words matter. And by advocacy, I mean the quality of advocacy, not the quantity of advocacy. And participating in things like the Spong tournament, you develop the quality of your advocacy, and you'll take it into your career and hopefully back into your communities and put it to good use after graduation. So I know this is a very different year than when I spoke to this group last year, but I congratulate you all on participating. And I'm going to pre-congratulate a few folks that I'm getting ready to give some awards to. So I'm going to jump right into it. The best oralist is Team 2130, University of Georgia, Taylor Lear. And Taylor, with some limitations, I'm sure there's lots of cheering, but I will clap and cheer as I might be the only one on video and with my microphone off. So congratulations to you. Best brief, Petitioner, is Team 2136, Washington University, Lynn Nguyen, John Purcelli, and Theodore Van Beek. Congratulations to you. And the best brief respondent is Team 2135, George Mason University, Sydney Jaleef, Malin Maurer, and Tim Swartz. So congratulations to you as well.
All right, you can't get rid of me for too long, everybody. So each year we have competitors ask, usually in person, who is William Spong and how do you pronounce the name of our tournament? Well, our tournament is named after our beloved late Dean, Dean William B. Spong Jr. Dean Spong served from 1976 to 1985. He was a native of Portsmouth, Virginia, and earned his LLB from the University of Virginia before pursuing postgraduate studies at the University of Edinburgh. During World War II, he served in the Army Air Corps, and after the war, he returned to Virginia to lecture in law and government at the College of William and Mary. In 1954, Dean Spong began a distinguished career in the public sphere. First in the House of Delegates, then in the Virginia Senate, and ultimately served in the United States Senate. In 1975, he returned to William and Mary, and the following year became our law school dean. He remained with the law school until he retired in 1986. If you hang around William and Mary Law School for a few hours, you'll usually hear something about being a citizen lawyer. Being a citizen lawyer means different things to different people, but at its core, it refers to a lawyer who is keenly aware of their responsibility to wisely lead their communities and fiercely advocate for justice. Dean Spong was well known for his character. Representative Bobby Scott noted he used principles as his guide rather than for personal or political gain. I wish more politicians would take his lead. Senator Charles Robb said that Dean Spong inspired more people than probably we will ever fully imagine. Dean Spong is the embodiment of a citizen lawyer, and this is why we named our tournament after him and honor his legacy every year. I am now excited to introduce each of you to our current dean, Dean Benjamin Spencer, who I'm sure Dean Spong would praise as a citizen lawyer as well. Dean Spencer joined us over the summer during one of the hardest summers of many of our lives, and he hit the ground running. Dean Spencer received his BA from Morehouse College, his MS from the London School of Economics and his JD from Harvard Law School. He is an expert in civil procedure and federal jurisdiction and has authored 2 books that you may have used in your civil procedure classes. One, Acing Civil Procedure, and the other, Civil Procedure, A Contemporary Approach. After graduating Harvard, Dean Spencer joined the Army as a U.S. Army Reserve officer. In an article by the U.S. Army Reserve, Dean Spencer said he joined the Army because he felt a calling to serve people and his nation. In the article, when asked about his accomplishments and being named the first Black dean of the country's oldest law school, he said he remains humble and commented, "I'm not really into stories about myself. It's not about what I've accomplished and achieved." He said he sees this as an opportunity to serve others, a calling to live as an example for other Black men and women and to fight to open doors for others. To say that William and Mary is lucky to have Dean Spencer is an understatement. I wish that you all could have met him in person this weekend, and honestly, I wish that I have met him in person as well. But I promise you, he is just as charismatic and inspiring over Zoom. Without further ado, please help me in welcoming our Dean, Dean Spencer, to welcome and announce this year's Spong Award recipient.
Thank you, Heather. That was quite a very generous and humbling introduction. I really appreciate that. I'm very excited to be here virtually with each of you today. And I'm extremely excited to introduce all of you to my friend and mentor, Judge Roger Gregory, and present him with this year's William B. Spong Jr. Award. As Heather noted earlier, every year, the William & Mary Law School Moot Court team honors the late Dean Spong's service as an educator, a statesman, and an advocate by giving the Spong Award to a judge who not only possesses similar qualities as Dean Spong, but someone who also is the embodiment of the core values of our law school. William & Mary Law School is built upon a strong foundation of core values: leadership, insight, inclusion, community, and progress. All of these values contribute to our unified goal of creating and maintaining a community of citizen lawyers. A citizen lawyer is not only an excellent legal advocate, but also an advocate and an active leader in their community. Judge Gregory is the true embodiment of the citizen lawyer. After being the first person in his family to graduate from high school, Judge Gregory continued on and graduated summa cum laude from Virginia State University, and then earned his JD from the University of Michigan Law School. After completing his education, he went on to work in corporate law with the law firm of Butzel, Long, Gust, Klein, and Van Zyl in Detroit, and then joined Hunton and Williams in Richmond. Only 4 years after graduating, he partnered with future Virginia Governor L. Douglas Wilder to form the law firm Wilder and Gregory. He led the firm for 15 years. During his time as an advocate, his colleagues described him as very engaging, self-effacing, and as a man of very even temperament. During his trials, his colleagues praised his ability to think quickly on his feet and to elicit frank testimony from witnesses in a low-key way. They described him as succinct. He would establish his points quietly and effectively and move on. When referring to his character, they described him as a man with a smile, with a willingness to engage whatever the project might be. He has been regarded as even-keeled without being a pushover, a community-minded leader, and a skillful lawyer. After nearly 20 years of practicing, President Clinton nominated Judge Gregory to a seat on the Fourth Circuit. When President Clinton announced his nomination, he called Judge Gregory one of Richmond's most respected trial lawyers. Upon notice of his nomination, his former law partner, Governor Wilder, commented, "If there were any other person more deserving of this honor, I just don't know him." But Congress ended their session without addressing Gregory's nomination. However, President Clinton persevered and appointed Judge Gregory during a Senate race, but this appointment lasted for only 1 year. Judge Gregory's future on the bench was left up to President George W. Bush. and whether he would reappoint Judge Gregory for a permanent placement on the Fourth Circuit was uncertain. But President Bush did just that, and the Senate confirmed Judge Gregory in 2001 with a 93-1 vote. Judge Gregory was the first and only person to be appointed to a federal appeals court by presidents of two different parties. Judge Gregory has been a trailblazer his entire life. He was the first person in his family to graduate from high school and then attend college and receive his JD. He was the first African-American attorney at the firm of Butzel, Long, Gust, Klein, and Van Zyl in Detroit. Then he was the first African-American to join the Fourth Circuit, and later the first to serve as its chief judge. It comes as no surprise that he is also a trailblazer for many others. While serving on the Fourth Circuit, he joined the majority in Bostick v. Schaefer, which overturned the same-sex marriage ban in Virginia. In Bostick, the court described civil marriage as one of the cornerstones of our way of life. A choice of whether and whom to marry is an intensely personal decision, and denying same-sex couples this choice prohibits them from participating fully in our society, which is precisely the type of segregation that the 14th Amendment cannot countenance. Judge Gregory also authored the court's unanimous opinion in King v. Burwell, which upheld tax subsidies under the Affordable Care Act. In his opinion, he said, "We find that the applicable statutory language is ambiguous and subject to multiple interpretations. But in applying deference to the IRS's determination, we uphold the rule as a permissible exercise of the agency's discretion." After 15 years on the bench, Judge Gregory took over as Chief Judge of the Fourth Circuit. As Chief Judge, he authored the opinion in International Refugee Assistance Project versus Trump, upholding the block on President Trump's revised travel ban. In his opinion, he noted that the president's power to deny entry may be broad, but it is not absolute, and noted the president's power cannot go unchecked when, as here, the president wields it through an executive edict that stands to cause irreparable harm to individuals across this nation. Throughout his time on the bench, he has proven himself as a strong advocate for the rule of law and has used his position on the bench to vindicate injustices. Even though we cannot welcome Judge Gregory in person to our campus this year, please join me in virtually welcoming Chief Judge Roger L. Gregory as this year's Spong Award recipient. Judge Gregory, congratulations.
Thank you so much, Dean. Thank you so much. Listening to you talk about me, as my late parents would say that my father would be proud and my mother would believe it. Thank you so much. I appreciate that. I'm very humbled by receiving the prestigious Spong Award from William & Mary Law School, one of this nation's most prestigious law schools and the nation's oldest. It is all the more special to receive this award here on the 50th anniversary of the annual moot court named for Dean Spong, and also because it is the first academic year of Dean Spencer. And let me extend my official congratulations to you. I did so personally, but officially, and give you best wishes, and also congratulations to William & Mary Law School. Dean Spencer is a friend of the Fourth Circuit. In fact, he represents our circuit by appointment of the Chief Justice of the United States to the Civil Rules Committee of the Administrative Offices of the United States Courts. Yes, he helps us as federal judges draft the rules, a weighty job that he is awesome in doing. In fact, he is a preeminent educator, scholar, and lawyer. And so it is so wonderful to have him as your dean. And I think about being a teenager in Virginia, going to public schools, and as I recall from Senator Spong, he would be very pleased that Dean Spencer is the dean. Let me say this, and you've heard about Dean Spong. and his wonderful career and his great character. But I thought I would just briefly share with you 3 gems from Timothy Sullivan, who was the former president of William & Mary College. And back in 1975, he was chair of the dean's search for a new dean for William & Mary. And this tribute can be found in William & Mary Law Review, Volume 39, Number 4, March 1998. As I said, I've extracted 3 gems from this eulogy. And I thought so because I think it would be important not just to know the resume and those things about Dean Spong, but 3 things you can take away as law students as you will soon, in a few years, or some for 3Ls, very soon, partake in terms of your profession. And here is what he said. First, leadership. When Bill Spong accepted the deanship, the law school faced, quote, from former President Sullivan, severe adversity. President Sullivan, in his tribute for Dean Spong, said this, quote, his leadership first healed a crippled institution and then raised it to a level of national distinction that none of us dare to dream. Isn't that a powerful word? Leadership that first heals and then it raises us to a level that we thought we could not achieve. What a beautiful expression of what leadership is. Remember that when you take your place in your community, in your profession, whether it's bench or bar, or you're working with your clients, lead first with healing and then to raise. The second attribute he talked about is stewardship. Bill Spong was a thoughtful and dedicated public servant, as you heard. He gave so much to his beloved Commonwealth of Virginia. President Sullivan wrote this. He said that he was a teacher and a builder who believed profoundly in the power of education and struck many a powerful blow for civility and civilization. What expressions? A teacher and builder, and he believed in the power. You are the recipients of that belief in his work of building the power of education. You prove it all the time, and you will for the rest of your professional as law students. The power of your education to meet challenges and to also to forge change. And the second part, I love this, struck a powerful blow for civility. The idea of respect and engaging in discourse in a peaceful and powerful but respectful way of civility, encouraging a civilization of justice and ordered liberty, that everybody can have a seat at the table, and the blanket of justice and our constitutional protection is big enough to cover everybody and give warmth and nurture. What a phrase. And third, friendship. I think there, President Sullivan truly captured the essence of Bill Spong's character when he wrote this. He said that he was a friend whose friendship made us laugh just for the sheer joy of it. A friend whose love gave us strength, and a friend whose example gave us courage. You lead and you work by the joy of understanding the beauty of humor and goodwill and giving others love so that they might find strength, and lead by example of character and integrity. And that's what he did, and that gives us courage. As lawyers in the future, people will look to you. They may not express it, but they look to you in admiration and awe, sometimes respect that, because your example can give them courage and your love strength. And my concluding thought about this is that, recognizing the many contributions, I want you to remember the law faculty of your respective schools. I know that you came here by some hard work of yourself, but pouring in from some wonderful faculty. The brilliance that your writing, your written work, and your oral advocacy is really a light from many lamps. Appreciate those lamps. I know to this day, I cherish my law professors from Michigan, and I know you cherish your law professors. Thank them, because in years to come, these nuggets that they pass in the class, all through sometimes an excruciating Socratic method, but it is well worth the toil because it will wrought incredible excellence in advocacy and professionalism. And I conclude with President Sullivan's beautiful expression about how Bill Spong was a consummate teacher in all circumstances. Because this moot court is about teaching and learning and showing off your wonderful brilliance, which you have done. And in final rounds, I judge so spectacularly. But this is what he says, I conclude. As a teacher, Bill was almost magical. He taught without seeming to teach. We learned without realizing that we were being taught, until afterwards, when we were left to discover with manifest joy the power of the lessons he had lodged deep within our hearts. What will your leadership, stewardship, and friendship leave deep within the hearts of others? We're all waiting for your contribution. God bless you, be safe, and stay well. And again, William and Mary, thank you for honoring me with this wonderful award. I shall always cherish it and hope to live up to just be a fraction of what it represents and how much it means to me. Thank you so much, Dean and William and Mary family, to all the participants. Thank you.
Great. Thank you for those wonderful remarks, Judge Gregory. And it is our honor, as always, to have welcomed you and to have awarded you this great honor. If we can have you stay on for one more minute to announce the winners of the tournament, which everyone is waiting idly by. We're going to pull back up our PowerPoint so that we can show everything. All right. And now, Judge Gregory, whenever you are ready to announce the final winner.
Yes. I am pleased to announce that this year's winner of the Spong Moot Court competition is Team 2140 Respondent. Congratulations.
Alrighty, and thank you all so much for joining us. That means that our runner-up team is Team 2135 from George Mason University. Thank you all so much. I'm going to turn it over to our Chief Justice.
Thank you all and good evening. My name is Alexis Rodas and I am the Chief Justice of the William & Mary Moot Court team. First and foremost, I want to thank you all for spending your Valentine's Day evening with Team Spong. I want to thank the Spong team and Heather Pearson for their tireless efforts in organizing this tournament, and to our judges, the competitors, and the volunteers for making it such a success. We truly could not have done this without you. I also want to extend my sincere congratulations to all of the teams who competed in this weekend's tournament. The competition was fierce, and you should all be extraordinarily proud of how you navigated this problem and this new virtual format. As Heather said, this year was not only our 50th annual William B. Spong Moot Court Tournament, but it was our largest tournament yet. And as many of you know, this year was our first ever virtual tournament. This presented a number of different challenges, both to our team and I know to our competitors. But it also allowed us to welcome teams and judges from around the country who otherwise may not have been able to join us. And for that, we are very, very grateful. We hope that you will all join us again next year to celebrate in person. So I just wanted to thank you all again for joining us this weekend, and I hope you enjoy the rest of your evening. Thank you.